This is a follow-up to a live stream I've just been on regarding Ford Wrangler Michael William Kaiser. And I just wanted to do a standalone video just on the reasons for the dismissal of his case. I obtained these documents, in fact a lot of documents from his murder case, but for this purpose of this video I just want to go through this one document and make a point at the end, and hopefully we can assist the family in getting justice for the murder of Mr. Cameron. Okay, I'll start reading the state's request for reconsideration of order dismissing case with prejudice. Comes now the state of Alabama, by and through its Attorney General Luther Strange, and respectfully requests this honourable court to reconsider its order of January 22, 2016, dismissing the above style case with prejudice. As grounds for this request, that state avers the following. 1. The defendant was charged with a capital offence in the above style cause with regard to causing the death of Donald Cameron while in the commission of a burglary. On Wednesday, January 20, 2016, the state filed a motion to dismiss the above styled matter. The necessity for dismissal became apparent to the state as it was preparing for the February 29, 2016 trial date. During the course of its preparation, the state became aware that the May 13, 2013 indictment failed to apprise the defendant of each and every element of the charge of capital murder during the course of a burglary in the first or second degree as set forth in 13A-5-40 (A) 4. Specifically, the May 13, 2013 charging instrument reads, so rather than read out the original indictment, which they're saying was wrong, so there's no point in reading that one out in full, I will read out the indictment as it should have been, but I thought we'd look at the differences. And so the indictment starts, I'm not going to click on it, the grand jury of Calhoun County on that page there. There's a little footnote, but it's exactly the same. So I've highlighted where the differences are. And the indictment did say, knowingly and unlawfully entered or remain or attempted to enter or remain unlawfully in a dwelling and home of another, to wit, Donald A. Cameron, with intent to commit a crime therein, to wit, burglary in the second degree by unlawfully entering a lawfully occupied dwelling and home. And it should have said unlawfully entered or attempted to enter unlawfully in a lawfully occupied dwelling house of another, to wit, Donald A. Cameron. So they've got rid of, so the wording is slightly changed. So we got rid of knowingly, we've still got unlawfully. Entered is pretty similar. Remained has disappeared, or remain has disappeared. Obviously the wording of the house is slightly different. In a dwelling and home in the first one, occupied dwelling house in the second one. And we've got rid of burglary in the second degree. So that one has dropped from the indictment that they wished to amend it to. The main difference is they've got rid of the description of the burglary. It's actually shorter, is what they're saying. So let's read in full what the indictment should have been, but hopefully you can see the differential there. It's not great, not major differential. So this is what the indictment should have read. The grand jury of Calhoun County charges that before the finding of this indictment, Michael William Kaiser, whose name is otherwise unknown to the grand jury, did, with the intent to cause the death of another person, cause the death of Donald A. Cameron by shooting him with a firearm, and the said Michael William Kaiser caused said death during the time that he unlawfully entered or attempted to enter unlawfully in a lawfully occupied dwelling house of another, to wit, Donald A. Cameron, with intent to commit a theft or felony therein, to wit, theft of property in violation of section 13A-5-40 (A)(4) of the Code of Alabama 1975 against the peace and dignity of the state of Alabama. The state believes that the variances created by the May 13, 2013 were too significant to continue forward under this charging instrument. 3. On January 2016, this Honourable Court dismissed the case with prejudice. 4. The state respectfully requests that this Honourable Court reconsider its order of dismissal with prejudice. The state merely sought to dismiss the current indictment because of a defect in the wording as noted above. The state did not include any facts in its motion to dismiss, and the defendant did not supply the court with any facts regarding the merits of the case. And there's citation there. Black's Dictionary defines the phrase with prejudice as with loss of all rights in a way that finally disposes of a party's claim and bars any future action on that claim. Black's defines dismissal with prejudice as a dismissal, uzu, after an adjudication on the merits, barring the plaintiff from prosecuting any later lawsuit on the same claim. If after a dismissal with prejudice, the plaintiff files a later suit on the same claim, the defendant in the later suit can assert the defence of res judicata (claim preclusion). And citation. 5. While the state recognises that the court is the final authority with respect to the ultimate disposition of a case, it respectfully asks for reconsideration and modification of the court's order to nolle prosequi, or dismissal without prejudice, due to the nature of this case and the impact dismissal with prejudice will have on the state's ability to seek justice in this matter. And that was dated the 25th of January. This motion was granted, so the case was dismissed without prejudice. So somewhere the ball has been dropped. The family hasn't got justice. No one has been alleged to have been the perpetrator, I believe, other than Michael William Kaiser. I know the family wants justice, and really this video is made purely to ask for any assistance for the family in getting the current prosecuting authorities to reopen the case against Michael William Kaiser. Now, if Michael William Kaiser had stayed off the internet, this video definitely would not be being made. He did go onto the internet. His presence on the internet is not liked by the family. And all you people who are watching his streams, watching his adverts, donating your money in memberships, etc., have a hard look at yourself. We have proven stolen valor. We have proven multiple felonies with ongoing charges. And we also have the elephant in the room, which is the murder, which I hope you can see from this video that when the charges were dismissed, they were dismissed on a technicality regarding the wording of the indictment and nothing else. And at the time of dismissal, it was the intention of the state to continue with the prosecution under the new indictment. What I hear from the family is that they were told incorrect reasons as regarding the dismissal. They weren't told that the indictment was worded incorrectly at the time. Thanks for watching. I'm sorry that was a bit in detail regarding the differentials between the indictment, but it was just to show how a few little words appear to have enabled Michael William Kaiser to maybe get away with murder. Thanks for watching.